In today's video, we're going to talk about Section 21 no-fault evictions being abolished. Is this good news for tenants? Maybe. We're going to discuss that and more. So welcome to Property Insight. My name is Neil Harding.
And I'm Mark Ashworth. Section 21, the no-fault eviction notice that landlords and agents provide tenants if they want them to move on. Yeah, there's obviously been a lot of talk about this in the industry. Often, well, certainly in the property industry, a lot of landlords and investors are talking about how it's going to affect them. But actually, I think a more important point is how will that actually affect tenants?
So a Section 21 notice is an eviction notice that a landlord can issue to a tenant, providing them with 2 months' notice to vacate the property. And It's called so-called no-fault eviction because a landlord does not have to give any reason whatsoever when they issue that notice. The reason is given, then sometimes a landlord will go through a Section 8, and there are all sorts of reasons why they might go Section 8. For example, non-payment of rent could be a valid reason for Section 8, but Section 21 is the one that I think, to be honest, most people don't really like, and it's perhaps even one that people think gives landlords a bad name. And I don't really like the idea that a tenant in society can just be issued with a Section 21 notice for no reason whatsoever and they lose their home. I don't think that's great.
I think what's being misrepresented here is the fact that Section 21 notices are often given because there is fault. And the reason why they're given because there's fault is because they are the easiest to get through the courts. Because the court system's broken, and if you do serve a Section 8 notice for, let's say, antisocial behaviour, which is probably the next thing, or the next most common thing to be evicted for other than non-payment of rent, what it means is that then that has to go to court and the judge has to decide whether or not there is enough grounds for antisocial behaviour because the grounds are discretionary. So therefore, in order to make it easier for landlords and letting agents to move on or allow people to move on is by serving a Section 21 notice. So all of the data that you read about how many Section 21 notices are served by the likes of, well, let's say tenant-based organisations, maybe the charitable ones that are non-profit, talk about these statistics, in my view, in a completely skewed fashion because they're just not used correctly. This is a massive issue, and this is why I think, and we both actually agree, that we think that this is going to have a negative effect on tenancies and on tenants itself. Because what will happen is that...
In some cases,
because the advice they're being given at the moment by some councils are that they should wait for a notice to be given, which is a Section 21 notice. We can probably come on to that. Let's go on to actually what's happening. So
what's happening
what stage
recently?
Are we at in terms of how far this has gone through the system?
So on the 24th of April, the House of Commons read the Renters Reform Bill and discussed in particular the effect of Clause 30. Clause 30 is the section that Mark's just been talking about, which deals with the painfully slow process of going through the courts that landlords have to go through in order to get vacant possession of their property and evict the tenant. And this is why quite often a landlord in the past will have used Section 21, as we were just describing, rather than Section 8, because there are probably just less hurdles and technicalities to have to go through, and you're more likely to at least go through that quite long protracted process and at least actually get vacant possession at the end of it, rather than falling foul of some technicality. One of the problems that they've realised of abolishing Section 21 is that, well, where does that actually leave landlords that reasonably do want possession of their property where they need to evict a tenant for maybe they're not paying rent, haven't done for months or even years? If the courts are in a mess, is that really fair? Probably not. So they have decided that the Lord Chancellor is responsible for making an assessment on when the courts are fit for purpose, and only when they are fit for purpose, in a nutshell, will Section 21 be abolished for existing tenancies. It remains to be seen exactly when that is decreed, but at some point in the future it presumably will be. And what's also interesting is it's when they describe when they talk about the court process, it's not just the judge in a room making a decision. It feels, which is I think a good thing, more like the end-to-end process from application to the court through to actually having an available county appointed authorised bailiff to actually evict. Because let's face it, sometimes it's months to wait for the bailiff to actually arrive. You go through all that process with the court and then it's still got to wait months for the bailiff to come, which, as you said, councils, local councils, more often than not, advise tenants to wait until the bailiffs come before they become a priority for them to rehouse people who are either homeless or threatened with homelessness. All of this means that actually the law might change on this bill as soon as potentially May 2025. We might see as early as that Section 21 is abolished. So to pick up on this point about the council's responsibility to rehouse homeless people or those threatened with homelessness, let's just have a look at exactly what the council's responsibilities are right now. So they include a number of things, but it includes their duties arise in the following when the following conditions apply. So they are homeless or are threatened with homelessness. They might fall into a priority need category. There might be a vulnerable person. There might be a young family with young children. They also talk about people that have made themselves voluntarily homeless. In particular, criteria states that they have not made themselves voluntarily homeless. So with a Section 21, that is clearly not their fault. It's a no-fault eviction. They haven't voluntarily made themselves homeless. There's nothing they could do about it, at least in theory.
Yeah, so obviously if the Section 21 notice has been served and they have a date to leave the property and they don't leave the property, you then need to instruct the court in order to go through that process of checking all the documentation was correct before they grant eviction or an eviction notice. They then may grant that eviction notice. But then if the tenant still doesn't leave, that's when it's up to the bailiff then to ask them to be removed, and they'll have a removal date, a date being given to effectively evict and change locks, etc. But obviously, if the tenants stay in the property until that time and the bailiffs come round, then there's an argument on the tenant side to say that there is literally no fault. But the issue here is that if certain councils are giving people advice to stay in their properties until they've been evicted, and this no longer is the case because of the Section 21 has been abolished, then there's going to be all sorts of ramifications around people who are A, not paying their rent, and B, essentially antisocial behaviour. I can't really think of any other legitimate reasons why a good quality landlord would want to remove a good quality tenant from a property unless those things were being breached.
Yeah, I think the point, I guess, what we're trying to make, Mark, is that in a world where all evictions are fault evictions and where landlords have to prove fault through a court process, and off the back of that, the judge awards vacant possession because of the fault of the tenant, is the local authority and the council still legally obligated? And will they, anyway, regardless of the legal point, rehouse that person?
In my personal view, I think this could lead to more homelessness because of the...
Or at least a risk of it. Yeah.
Absolutely. Yeah.
I think it also, and by the way, like Mark and I aren't trying to make small, sort of poo-poo sort of the risk of and the very real seriousness that tenants get Section 21 notices through no fault of their own. Clearly, there are hundreds and thousands of people that receive a Section 21 notice and it's completely unfair on them. And I think we absolutely respect that point.
Yeah.
But I think what we're trying to say is we're not seeing anywhere in the legislation or in the narrative or in the media anything that represents the voices of the tenant. And I've got one right now, by the way, who asked me for a Section 21 notice because they wanted that, because they'd rather live somewhere else.
But that was the advice they were given, right?
And they'd rather live somewhere else where the council places them into a more suitable place for them to live. And I bought this property as a tenant in situ. I didn't put them there in the first place. They've just told me the day I bought the property, I want to live somewhere else. I want to live in a different area of the city. I want you to give me a section 21. It was the very first conversation I had with them the day I met them. So in that scenario, what happens for that person in the future? Do they have to stop paying me rent before they can get a Section 8 notice? And then that ruins their credit score and credit rating, so they can't ever get a credit card in the future? Or do they have to start behaving antisocially in order for me to give them a Section 8 rent? I mean, it's obviously ludicrous scenarios I'm saying here, but I just don't yet know how those pieces of the jigsaw fit together. So on that cheery note, it's really a thought experiment at the moment, and I think it's Mark's and mine reflections on our concerns with the bill as it stands at the moment. And actually, I think we're just hoping that we see more thought given to that and probably more narrative and discussion in the House of Commons and in the final bill before it's passed. And let's hope that they think about all this properly and come up with something that's actually a lot more sensible. So we hope that you've found that insightful. And if you have, please do comment, like, and subscribe to the channel and share the content. And we look forward to seeing you on the next video.